My question relating to docket 636 on exhibits that the state has led you on, occurrence books, charge sheets, and other related exhibits. But what is of essence in this question relates to the occurrence book. Is there in the occurrence book of respective police stations wherein either accused number 1 or accused number 2 was booked in or out under case number 636 of 10/2014?
Well, one that I remember, my lord, in Albertine, when he was booked in for pointing out, it's clearly reflected that he was booked in for the pointing out under case 636 of 10/2014.
Mina ufuna ukwazi-ke ukuthi manje-ke la ngokumayelana nomsolo wokuqala nowesibili kukhona yini kulama OB books bekukhulunywa ngawo lana la kubhukwe in khona na-out umsolo wokuqala bebhukwa phansi kwaleli icala eliwu-636 lobhekadi akhumbulayo-ke yileli eliwu-636 la ewayokwenza khona-ke i-pointing out ibhaliwe-ke icacile lapho ukuthi u-636.
It's 636 for the first time from their date of arrest.
My lord, the accused, as I said earlier, accused 1 was arrested for a different matter. The warrant of arrest was, J50 was executed in relation to the drug dealing case of Tembisa 217 of 3/2019. He was in custody on that matter. So obviously the movement of him, it will relate to that matter until this matter becomes relevant.
Bese ngishilo ukuthi-ke i-warrant eyakhishwa-ke kwakuyicala-ke leli ley'dakamizwa laseThembisa eliwu-217 3/2019 bese kuthi-ke manje-ke ukuhamba kwakhe-ke umsolwa-ke ehambela lona lelo cala-ke kuze kube yisikhathi la khona-ke manje leli icala lona-ke nalo liyavela.
Yes. On the same murder charge under a cold case, my worry in terms of the investigations prior to accused 1 and 2, including 3, 4, and 5, appearing for the first time in Boksburg Court. At that stage, there was no direct, I would say, there was no direct evidence linking. Sorry, may I rephrase this question? Sorry, I don't want to confuse the months. At the time, Sibia was arrested on the 30th of May 2020. He was the first person to be arrested. Is that so?
He was the first person to be arrested for Tembisa case 217 of 3/2019.
Waye umuntu oqala uSibiya ukuboshwa eboshelwa icala laseThembisa.
Yes. But will you dispute that immediately or at the time of his arrest, he was interviewed about the case of Senzo Meyiwa 636?
No, it's not in dispute, my lord. But he was also interviewed on other matters where he was also a person of interest.
Angeke ngikuphikiseke ukuthi-ke yebo uma eboshelwa lona icala laseThembisa ukuthi kwase kuba nenhlolo khona-ke mayelana necala leli laSenzo Meyiwa hhayi kungesilona-ke kuphela namanye amacala-ke.
Yeah, let's just focus on this one. I understand they are relevant, those cases, in terms of your investigations. But in relation to 636, on his interrogation or interview regarding the death of Senzo Meyiwa, the state at that time had no evidence that linked accused number 1 with the death of Senzo Meyiwa.
I'm not sure, my lord, if we can say that, because what led us to him there were fingers pointing to him that he was involved in the killing of Senzo Meyiwa, and eventually when we got to him, more evidence was found, and hence we are standing before this court. He's charged for the killing of Senzo Meyiwa.
Mmeli uthi ke yebo ke uma esethweswe lelo icala ke lasethembisa kodwa ke uma manje ke senibuza ke imibuzo mayelana necala lika Senzo Meyiwa kwaba babungekho ubufakazi ke ukuthi uyambandakanyeka ke uBrigadier ke uthi kavumelani ke nalokho ngoba ke yayikhona ke iminwe eyayikhomba kuyena ke sathi uma sifika kuyena ke sathola obunye ke ubufakazi kuyena ingakho manje simila kule nkantolo.
Now I understand the logic of your answer, but the question still stands. When he was arrested on the 30th on a J50, let me say, before he was approached by Sergeant Mohola and Sadike and Buthelezi, the state had no evidence against him until such time accused number 1 made the alleged confession.
I disagree, my lord. This is what I'm saying. For one to focus on a specific individual, there must be basis in the form of a statement or intelligence or a source saying this person committed this crime. So you can't just go and question a person when there's no basis for that person being implicated.
Angivumelani ke naloko okushoyo ukuthi kwakungekho ubufakazi ngaleso sikhathi ke kuyena ke ngoba ke awungeke nje ukuthi uye emuntwini ke ube sokhulumisana naye ke ungenabo ubufakazi ke noma ke ukhona umuntu nje othe noma sikhona nje istatement kodwa ikhona nje into ezokholela kuloyo muntu leyo.
Yes, those are the links towards obtaining what you are investigating. But what I'm saying, the evidence at that time before his arrest dependent on the information of the informer. Is that so?
No, it's not what I'm saying. I'm saying, my lord, when you approach someone, you have to have a base, whether it's information from the source or a statement making certain allegations. All that I'm saying is that there was a reason for us to focus on Mr. Sibiya. So I'm not saying it's a source, because I'm now getting the impression as if I'm saying there's a source. There's a statement, my lord, in the docket which we disclosed to the defense again of Mr. Adv Mngomezulu. It's clearly implicating accused number 1 and number 2 in this matter. And that's what led us to focus on accused number 1 and 2.
Angishilo ke lokho manje sengithola ukuthi umeli ikona ke manje akusho ukuthi ke ngithi sine source noma kwakunomuntu owasitshela ke kodwa engikushoyo ke ukuthi kukhona nje okuba khona okukholayo noma information oba nayo ke ezokholela kuloyo muntu loyo ukuthi uyokhulumisana naye ke futhi ke ngiyaphinda futhi ke nanjengoba ngishilo ngaphambili ukuthi nalana ke kwidokodo sikhona ke istatement sakhe uAdv Mngomezulu abameli banolwazi lwaso leso statement leso yena ke futhi oshoyo ke ngokubandakanyeka kwakhe uAccused 1 and 2.
Adv Mngomezulu, as you say, his statement has been discovered. Now, when accused number 1 was approached, he was not approached with that statement. Do you agree?
My lord, there was a basis. You don't approach suspect and show them the statement that person X. I mean, you'll be compromising witnesses and people's lives. Yeah, I mean, that's not how investigation is done. I'm simply saying there was a reason, there was a basis, and I'm mentioning this name because we disclosed the statement. If it wasn't disclosed, I was not even going to mention this name. But I'm simply answering counsel to say there was a base as to why we approached accused 1, because in that statement of this particular person, accused 1 and 2 are implicated as being involved specifically in the killing of Senzo Meyiwa.
Lana kumele uthi manje kodwa uma uyakena ke number 1 awuyanga kena uphethe istatement leso sikaZungu uthi awungeke ukwenze lokho uphenyo lenziwa ngaleyo ndlela manje ke usuzobeka impilo yomuntu noma yabantu engcupheni uye kumsola uphethe istatement uthi ubani nobani bathi ngawo kodwa ke esakwenza ukuthi ke njengoba ngisho ukuthi siye sinaso isizathu esisibangela noma esisiholela ukuthi siye kubona siyokhuluma nabo ngoba amagama abo akhona uyabachaza lapha kulesa statement sakhe yena ke uMr Zungu ekuyisona istatement abameli ababe naso ngaphambi kokuthi icala liqale.
All right. The basis for this question is will relate to the voluntariness and the element of the accused being free to make a statement. When Constable or when Sergeant Mohola, after she executed a warrant, ultimately accused number 1 was arrested. The approach was mainly on the execution of the warrant. Are you with me there? Because my question is mainly based on the elements that we need to prove under Section 217, freely and voluntarily.
So we're dealing, I suppose, are we now on the confession part? Maybe just to understand,
No.
because Sergeant
No, it's part of the confession, it's part of the contestation of the 217(1)A.
Yes. So
My question is, let me just rephrase it in order for us to understand. I'm saying, when the J50 was executed on the 30th of May 2020 by Sergeant Mngomezulu to accuse number 1, the sole purpose was at that time hidden in relation to the death of Senzo Meyiwa, to approach accused number 1 with the J50.
Well, my lord, I don't know how you hide a J50. The warrant of arrest, when it gets issued, firstly it's signed by the NPA, then it gets signed for the final authorization by the magistrate, and that's the procedure. So you have to make your case. So I'm not sure how the NPA and the magistrate from Tembisa will disregard the facts before they may hide Senzo Meyiwa. I don't know.
So I think, Mr. Just to interject, sir, I wanted to, before you can interpret it, I wanted to clarify the question. Yes. I was saying the sole purpose of executing a J50 has been executed by Sergeant Mngomezulu to accuse number 1. That's the purpose of the J50.
I'm answering that, my lord.
Yes.
So first I was...
Now I'm saying, when she executed the J warrant, when the J50 warrant of arrest, she already had a prior knowledge of how accused number 1 is linked with the death of Senzo Meyiwa. That's prior knowledge I'm talking about.
Which is not a crime, my lord. So Sergeant Mohola is part of the investigation team. And I've indicated, my lord, that when this affidavit was disposed, we're seized with the docket. And suddenly we get a link that points us to 2 individuals. Analysis around these individuals were done, and these cases in relation to accused number 1 were picked up. Tembisa case, and it's not the only case. There is phosphorus cases where he was actually tried and finalized with a conviction, my lord. So when he was approached on the Tembisa matter, this was not the only warrant. There was a warrant of arrest insofar as the phosphorus case where he shot a female officer there. I don't mean to defame, I'm just trying to show that this was not the only case. So to say there was a hidden agenda, there was another warrant that was existing, and eventually after arraigning him on the Tembisa matter, the phosphorus matter was then executed, he was tried, finalized with the conviction. So there was no hidden agenda, and that is before the matter before this court.
Kukho okwakufihliwe lana nokuthi ke uMngomezulu ke kukhona awayekwazi ke yebo ke lokho akusona ke icala ukuthi khona ke wayekwazi ngoba makuyiwa kuyena ke ngalo icala leli laseThembisa kwangasilona kuphela ke ukhona laseForcegas usewasho ke ukuthi kwakuyini ke lapho ude kayimisele nje ukuthi ke phansi ke kodwa washo ukuthi ke kwagijulwa owesifazane khona lapho lalikhona ke futhi naleli ke kwakuwa namanye amacala kwangasilona nje kuphela leli elaseThembisa noma iForcegas kodwa namanye futhi amacala.
Furthermore, my lord, to assist on that, because counsel referred to section 217, Sergeant Mohola, by the virtue of her rank, she's not a commissioned officer, and therefore not the justice of the peace. So she could not, I can't put her into that category. Perhaps that will apply when you speak to officers.
Futhi ke ngizwile ke ummeli ekhuluma ke ngayo section 217 ngokwesikhundla sakhe ke anaso ke emaphoyiseni uSergeant Mkhula ke akumbeki ke lokho la kuthiwa khona ke ama officers ke a commission ke manje uma ukhuluma ke ngama officers ke mhlambe ke ungakusho ke lokho hayi kuyena.
I was not relating 217 with Sergeant Mkhulu. She's a surgeon. I'm well aware that she cannot take a confession. But for the first time, when she gave evidence that accused number 1 said something in relation to the death of Senzo Meyiwa, it was at the time she executed a J50 of 217/03/2019. That's the first time Sergeant Mkhula said to this court that accused number 1 said something like an admission, but she was well aware that she cannot take this other than informing Brigadier Gininda. Do you agree with me?
I agree with that.
Uma uthi ke yebo uma uthe yena uma eya kumsolo wokuqala ke eya ke nayo ke J50 wabe esesho into ke yena ke ubukhula ase udlulisela ke kuGininda ke ukuthi ngoba yena ke engavumelekile ke ukuthi lokho angakuthatha noma ke angakubhala phansi wase ekudlulisela kuyena uBrigadier Gininda.
So let's move on. Section after the execution of the J50, a warrant was effected. An arrest was effected on accused number 1, and he was then taken to Foslorus. I just want to understand the reason. Maybe that has been communicated with you. What could be the reason for taking accused number 1 to Foslorus?
Yes, so my lord, I think in my evidence in chief I covered the aspect that said I was informed they are moving to Foslorus to do other investigations. When I was informed about these admissions, I then requested them to meet me outside Foslorus police station because they were on their way on investigation in relation to accused number 1. That's how we found ourselves outside the police station in Foslorus.
Ukuthi kwakungani ke aye eFoslorus ke bengichazile ke lokho uma ngiqala ngofakazi bami nabofakazi bami ke obuyinhloko ukuthi ke uma ke ngikhulumana nabo ke bangitshela ukuthi basendleleni ke eya khona eFoslorus beyokwenza uphenyo ngase ngibacela ukuthi ke asihlanganeni ke kuyona ipolice station yase Foslorus.
The reason why I'm asking this, Mr. Gininda or Brigadier Gininda, is that Sergeant Mkhulu told the court that after they allegedly found the ammunition in his shack, they then accused number 1 directed them to a hostel in Vusumuzi. The purpose was to retrieve a firearm, or was to investigate if there was a firearm that accused number 1 might be.
I'm not sure what to say, my lord.
All right, let me say, after he was arrested and after the ammunition was found in his shack, then they took accused number 1 to a hostel to look for a firearm.
Well, my lord, I think Sergeant Mkhula can best deal with those matters. I mean, she was there, she questioned the accused, they know what they did.
Yes.
I think she'll be in a better position to deal with those issues.
Ukuthi ke babeya ke hostel yaseVusumuzi emuva kokuthi kutholwe ke inhlamvu babese beyobheka ke manje isibhamu uMkhula ke uyena ke wayekhona owaxoxa ke noma wakhulumisana nomsolo wakhe uyena ongaphendula ngcono lapho.
And going to oh, I thought the court is
Me, if I want to talk, I'll talk.
no, I heard the court
No.
with the funny sound.
You'll hear me when I want to talk, Mr. Mngomezulu.
Yes. The purpose for going to Foslorus, it was not to do further investigations according to your evidence. which is compared to the evidence of Sergeant Mngomezulu,
No,
but was to look for the firearm in one of the hostels in Fort Lawrence.
well, my lord, if that is what Sergeant Mngomezulu said, that's investigation. If you go and look, if police officers embark on any search on the official capacity, that falls under investigation. So we are saying the same thing.
Mina nawe sikhuluma into eyodwa ke ngoba uma kuwukuthi amaphoyisa ayahamba nje khona lapha ayosesha bayobheka khona ke uma uthi wena bayobheka isibhamu uphenyo lolo.
Now I understand the meaning of investigation, and I don't want to be distorted in relation to the definition. My concern is that when he was taken to Fort Lawrence was to investigate other cases, which is new from what Sergeant Mngomezulu said. Sergeant Mngomezulu said, as they were preparing to go to Fort Lawrence, they received a call to say they must wait for you in Fort Lawrence police station.
As a God pleases, that is not
Yeah, that's
entirely
not the
correct.
evidence. We all know that.
No. It is. I'll support it. I'll support it. Because I'll take you from what Constable Buthelezi said first, before you get the logic of what I'm talking about. Constable Buthelezi said they phoned Munareng to wait for them so that they wanted a backup to go to the hostel. That's what Constable Buthelezi said. To do what in the hostel. Now, what Sergeant Mngomezulu said, and sorry, let me finish the evidence of Sergeant Constable Buthelezi. Constable Buthelezi said, when they were still at Tembisa, he called Munareng for a backup so that they can go to one of the hostels in Fort Lawrence. Do you understand, sir?
I do understand, I'm listening.
When they arrived in Fort Lawrence, the escort assisted them to the hostel where Sergeant Mngomezulu and accused number 1 entered the hostel under their guide.
My lord,
That is not correct.
It's the other way around. Let's understand the evidence. Otherwise, let's understand the evidence. After Sergeant Mngomezulu says they found that ammunition,
Yes.
her evidence is accused number 1 is the one who led us to a hostel where he said to us, we will find the firearm.
In Tembisa.
Yeah, right.
Yes.
And just before they went to that place, it's when she says she had a tete-a-tete with accused number 1, who informed her of certain admissions. And she says she excoriated her. Why didn't you tell us this before you were arrested? Now you should have told us. No,
Yes.
I knew one day I'll account.
Yes.
Then she, because as you rightly say, she's not a 217 officer, phones the brigadier to say, hey, accused number 1 has just made certain admissions to me. I think you must come and consult with him.
In Fort Lawrence.
And that's when they stop going to the hostel to look for the firearm, because he instructs them, come to the police station in Fort Lawrence. That's how I get the evidence.
That's correct, my lord. It's the same I
Oh.
heard. But now I was relating the evidence of Constable Buthelezi.
Okay, fine.
Because it came first before the evidence of Sergeant Mngomezulu.
Okay.
Because according to the evidence of Buthelezi, they ended up in Fort Lawrence. In Fort Lawrence, the discrepancy is that Constable Buthelezi led evidence which landed them in one of the hostels in Fort Lawrence. That's the difference between his evidence and the evidence of Sergeant Mngomezulu.
My Lord, I was not in court when they testified. What I'm saying is, when I was told by Sergeant Mukola that accused one is making some admissions, and they were on their way to forced arrest for investigation, I then said, not to step, the route that they were taking. Let us meet at forced arrest ACPS. That's how we found each other there with accused number one.
Lana ke okwenzekayo ukuthi uma ke umhula ubuthelezi benikezwe ngokufakazi ke ngangekho enkantolo angabaza abakusho. Kodwa mina ngikushoyo ukuthi ke uma ngikhulumisana naye ke uSergeant Mukhula engitshela ke ukuthi kukhona ke okuthize okuvunywa ke uyena umsolo wokuqala. Wase ngitshela ke ukuthi babe sendleleni eya eForce Lotus. Ngabe sengithi ke angaphazamisi ke indlela yabo noma laba yakhona ngase ngithi ke asihlanganeni khona epolice station yase Force Lotus.
I understand everyone. Constable Buthelezi explained the rights to accused number one. Sergeant Mohola explained the rights, constitutional rights. When you arrived, when you had the chance to speak to accused number one, you further explained the rights to accused number one.
My Lord, I don't, perhaps it's not put into the correct context to say further. I was not there when those rights were given. I, as the person who was going to question him in relation to this matter, I'm aware of the rights that he must be aware, that he must take note of in terms of the Constitution. So I explained them to him for the first time.
Thank you.
Mhlambe ke ukuthi ke babe sewachazeleke abanye obuthelezi omhula ukuthi nami ke ngase ngiqhubeka ke mhlambe ke akusiyona ke indlela yokuthi ngayisho ke le mina kwakuwokuqala ke mina ukuthi ngangizokhuluma naye ke ngikhuluma mayelana nalecala ke so ngangazi ukuthi kwapi amalungelo ngakufanele ngimtshele wona ukuthi awazi ngakwenza ke lokho.
And I'm not saying, my Lord, there were no rights that were given. I'm saying to me, because I was encountering the accused for the first time. It's a procedure. That's how you cannot just ask someone in relation to an investigation that possibly makes that person a suspect or a person of interest without questioning them of their constitutional rights. That's not how we stand.
Angisho ke ukuthi ke babe ngamchazelanga ke laba ayikhulumisana nabo ngaphambili ke kodwa ngikhuluma ngami ke manje ukuthi ngangizokhuluma naye ke akwazi ukuthi vele ukhulume nje nomuntu ke mhlawumbe ukhulume naye noma uzokhuluma naye ke into engamenza ukuthi abe umsolwa ubese ungamchazeli ngamalungelo akusiyona ke indlela ekwenziwa ngayo leyo.
My question, if I use the word further, meaning Constable Buthelezi explained the rights, Muhola explained the rights, and such rights were further explained by you to accused number one. That's how I wanted to put it. But there is evidence, as we have read it in examination in chief, that you read and explained the rights or the constitutional rights of accused number one in relation to the alleged admissions he has made at the police station in Force Lotus.
Yes, I'm not sure if I said I read. I didn't use the word.
No. You can delete it if you want to, but you explained it.
Yes.
It's a matter of how you...
And I've mentioned them, what rights did I give him.
Yes,
that's
getting into the
not
rights.
reading them, yes.
Yes.
That's correct.
Bese ngishilo ukuthi ke amalungelo wona ke okumchazela noma ngasho futhi ukuthi wapi ke engamchazela imaphi engamchazela wona.
You are explaining the rights to accused number one at Force Lotus police station. Firstly, I would say amongst the rights that you have explained, a right to remain silent.
Yes, amongst them, my Lord.
Kumalungelo engamchazela wona ke ilungelo ke lokuthula.
A right against self-incrimination.
Correct, my Lord.
Nelungelo ke lokuthi ke ungakhulumi into ezokufaka ke noma esho ukuthi uyambandakanyeka.
The rights or consequences of not remaining silent.
Yes, that if it does decide to say something that is incriminating, it can be used against him. That is correct, my Lord.
Nemiphumela ke yokungathuli ke ngamanye amagama ke ukuma kunento oyikhulumayo ukuthi lokho okushoyo ke kungasetshenziswa ngakwena.
The right to legal representative. If you don't have your own, you can get a state lawyer. if I
Correct,
may put
my
it
lord.
that way.
ilungelo lommeli nokuthi uma ke ukuthi ke akwazi uyitholela ummeli umbuso ungakulekelela.
And to challenge any irregularities.
Well, first, the first one, my lord, was a right for him to be detained in an environment that is suitable with human habitation.
Elinye ke noma lokuqala kilelo kumchazela ukuthi ufaneleke ukuthi ke ugcinweke noma uvaleleke kwindawo ke efanelekileke eyamthana ke nezimo zokuthi ke umuntu ufanele avalelwe kwindawo enjena.
It's one of the rights. Sorry?
Yes, and then of course the right to challenge the legality of his arrest, and if he feels that it's unjust, that he should be released with immediate effect.
Futhi ke nelungelo lokuthi ke uma ubona ke ukuthi indlela ke oboshwe ngayo ke noma ovalelwe ngayo ke ayihambisani ke nomthetho ukuthi ke ungabuyisa noma ungaphikisa ke lokho uma kutholakala ukuthi ngempela ke awuboshiwe ngendlela efanelekile unelungelo lokuthi udedelwe.
Did you explain the right to be presumed innocent until proven guilty?
My lord, I think we're not in a trial, with due respect. I didn't explain that right. I didn't think it was significant. At that time, he needed to know those rights that I've given him, and then indicate what he wants to do. For example, my lord, he could have said, I want an attorney. That would have been the end of this discussion. We're not dealing with the trial issues.
Manje ke ilungelo lokuthi ke ufanele ke noma ke ubhekake noma ubuko nanje kumuntu ke omsulaka noma ke ongenacala ke kuze kube isikhathi ke lapho na ke inkantolo yona ke ifinyela kwesinye isinqumo. Angisibonanga ke isidingo sokuthi ke lelo ke ngichazeke ngoba ke bengaqulwa cala ke lapha yana bekufanele nje ukuthi ngimchazele noma ngisho lana engiwashilo kuyena ebengathi nje cha ngifuna ummeli lapho ke iyaphela ke inkulumo yami naye ayisaqhubeki.
So
And my lord, I think those rights are clearly defined in section 35. You have a right of an accused person, a right of arrested person, and a right of a detained person. There's a difference. When a person appears before court, is an accused person. The court will want that person differently than what the police will do when they're arresting him for the first time on the street.
Futhi ke uma ubheka lamalungelo lana ke kunamalungelo ahlukene lana ke akwazi ukuthi wahlanganiseke khona ke lo muntu ke oboshwayo umuntu owumsola ophambi kwenkantolo nomuntu ke futhi ovaleleke uma umuntu evela phambi kwenkantolo ummangalela inkantolo ke yona ke izomexwayisa ngendlela ke eyehlukile nanje ngendlela iphoyisa uma limbophe esikade nomuntu elizomxwayisa ngakhona.
So are you telling the court that the right to be presumed innocent until proven guilty is a right explained during the course of the trial?
No, I'm saying for the purpose of the interview, we were not during the trial process. The purpose of what is it that he elects to do at that moment to take the investigation forward, those were the rights, my lord, that were relevant. Because if he had said to me, I want an attorney, be it private or state, then you stop and proceed with those issues. If he says to me, like he said, no, I'm comfortable, I don't need an attorney, then I need to speak to you, knowing the consequences of his responses, and that he was making such concession to a commissioned officer who is regarded also as a justice of the peace. You proceed. You cannot say now the trial issues must come into effect. We are not there, my lord. It's a stage that comes later. It's a process. So you don't just, that's what counsel is asking me. It's a further stage. That stage is the ground part. That's where you start.
Lana ke bekuseyi lana ke esisaqala khona ke la ummeli angibuza khona ke uma manje esesiya phambili ke uma bekuwukuthi wayishilo ke kumina ukuthi cha ufuna ummeli ngangeke siqhubeke ke sasizophela khona lapho kodwa ke manje ukuthi nje ngimchazele lawo malungelo lawo abese yaqoka ke noma uyakhetha ke ukuthi ufisa ukwenza kanjani noma ukuthini ke kodwa ke wangitshela ke mina ukuthi cha akamfuna ummeli futhi ke uyimisela ukuthi ke akhulumeke nami.
I understand the way you put it. A right to be presumed innocent in anticipation. Say for instance, accused number one, he made some sort of admissions which may have resulted in a confession of some sort. Do I understand?
He made a confession. The elements of the crime were all in there in what he told me, my lord. I'm not sure if you say sort of. I viewed what he was telling me as a confession.
Lokho angitshela kona mina ke kwakukhonyuluka ke ngoba konke ke nje okumayelana nokuphathelene necala ke kwakukhona kuyona yonke le yanto awayengitshela yona.
Yes. If you are comfortable or you precisely understood the meaning of a confession and its requirements. If the elements of the particular offense were explained or were coughed out by accused number 1, that's when it came to for you to make a decision that this is a confession. Hence, you had to call a person capable of taking a confession. Is that so?
That is correct.
Kuyiqiniswa ukuthi ke kuloka ngitshela kona ke bese manje ngezwe ukuthi yini ke manje lena i-confession ugonyuluka ukuvuma yila manje sengithatha isinqumo khona ukuthi manje angifoneleke umuntu ozongisiza ngokwenza khona lokho.
A person with such a wide experience in investigating cases, background of the law, there are certain things that to guard against when a person is making a confession. Do you know them?
I suppose the violation of their rights, my lord, which I think I guarded against that. I'm not sure what counsel perhaps wants to say.
Angazi ukuthi yini ke ummeli afuna ukuyisho ke ngoba ke yebo uma kuumuntu umuntu uyakhuluma kukhona ke izinto ofanele uyibhekeke enye ke ukucela phansi ke kwamalungelo akhe.
My lord, with your leave, may I refer a witness in relation to my cross-examination to a particular provision
Yes.
in the criminal procedure? Do you have a copy of the criminal procedure? Section 219. Can you please read section 219 for me? 219.
The highlighted part,
Yes, I believe so.
all of it.
No. Just, I think, section 2191.
So it says, evidence of any admission made extrajudicially by any person in relation to the commission of an offense shall, if such admission does not constitute a confession of that offense and is proved to have been voluntarily made by that person, be admissible in evidence against him in a criminal proceedings relating to that offense, provided that where the admission is made to a magistrate and reduced to writing by him or is confirmed and reduced in writing in the presence of a magistrate, the admission shall, upon the mere production at the proceedings in question of the document in which the admission is contained. That's what it says.
Yes. There's something I missed. It didn't refer to. So are you not reading section 219, capital letter A?
Well, you said 219.
I said
That's what I'm reading.
219.1.
That's what I'm reading. It's 219.
May I see that? I'm not referring to section 219, capital letter A.
No, 1. I'm reading.
Yes.
Capital 219.
One.
Yes, that's
Yes.
the one I'm reading. It relates to the magistrate.
Yeah.
It's a different grouping with the justice of the peace, my lord.
Yeah, all right.
It is 2191.
No. Say it's 219. Section 219. Can you check section 219 there?
Can I ask my lord that the counsel should just
Yeah,
highlight
maybe,
it?
yeah, you're right. Mr. Mngomezulu, read it for you. You can ask
Or maybe
Mr.
read
Junior
it,
to
yeah,
read
so I
that,
can
yes.
read it.
Because the witness says he has read what you said he must read. Now you're saying, no, read 219.
There's a difference. There's a section 219 and a 219 capital A. I think what Mr. Mngomezulu wants the witness to read is 219, which reads, no confession made by any person shall be an admission in evidence against another person. I'm not sure that's the section that you wanted to read. And by the way, I'm not a junior. I was admitted before him.
When I use junior, I don't use it in terms of admission status. I use it in terms of appearing in this court. He is leading you. You may be senior, but he is leading you.
Yes.
Mr. Mngomezulu, am I correctly interpreting the status?
Yes, in that context, he's my senior here.
Okay, they're fine, but let's be serious.
Yes, but
is that the correct section you want this witness
that's correct.
to answer on?
I'm relating to that section.
Just repeat it so
Yes. Just repeat it so that you get it.
It's section 219, and the title is Confession Not Admissible Against Another. And it reads, no confession made by any person shall be admissible in evidence against another person.
that. Okay, that's
Okay.
what. Okay, fine. You heard that, sir.
I've heard my
Nice.
You understood what was read. My question is, at the time when accused number 1 was making a so-called confession, I'm less concerned about the contents of what he related to you. Were you aware of this provision?
I was aware, but my lord, that provision does not talk about things that you must be cautioned of before. It talks about the confession made by one person that it cannot be used to another person. The only thing that I'm aware of is that the person must be aware of his constitutional right and make a selection of what he wants to do before admissions or confessions can be taken. Now that section simply tells you that you can't use the confession of person A on person B if they are both suspects. That's the essence of what was read to me.
Lokho kodwa ufunda la kumina ke noma ke engikufundelwa ke ukuthi nje uma kuukuthi othize ukhulumile noma ugonyelukileke lokho akushilo akukhoneki noma kwazeka ukuthi kungasetshenziswa komunye awumsolwa kanye naye kona nje lo kodwa akhulumike ngamalungelo ukuthi kufanele ukuthi qala ke kwenzeke nike kodwa akhuluma nje ngokusetshenziswa kwayo,
which is completely different in relation to the requirements for the admissibility of the confession, my lord, that it must be made free, voluntarily, without any undue influence. There's a difference, my lord.
Kuhlukeke lokho ukuthi manje lokho uma umuntu ukwenza ke engaphoqelekileke futhi ukhululekile nje kuphuma kuyena kuhlukile kulokho.
Now, please just focus on section 219. Why I'm concerned about section 219? For you to make a decision at that time when accused number 1 told you, you made a decision to call a competent somebody to take a confession. Having heard the contents of what he told you, you made a decision, a spontaneous decision, to call a person that can assist with the taking of the confession.
Yes, that's how the best practice, my lord, is done. I could have taken it myself, but it's normally preferred that someone independent should take such writing. That's how the best practice. That's how things are done all over the country.
Indlela ke kusetshenzwa ngayo ekwenziwa ngayo ke leyo ke ngangakuthatha ke noma ngikubhale ngokwami ke lokho awayekusho kodwa ke indlela ke ekuyiyona ukuthi ke kubizwe ke umuntu ongasiyona ke ingxenye yophenyo walelicala ingakho ke nami ke ngaxhumana ke nomunye.
And my lord, I was not so what perhaps must be clear, there was no confession that was being used against accused number 1. He was making confessions and arrangements were made for that confession to be taken down. So we're dealing with one confession. There's no other confession except the one he made to me and subsequently to use in writing to Colonel Mboto.
Ayikho ke enye eyayenziwe la ekwakufakwa khona ke igama lakhe ke yilena ke i-confession lena umsolo oqala yena ke la wayekhuluma khona ke ngakwase ke kuthola ngenza ukuthi kutholakala umuntu yile eyabhalwa ke uyena uKenneth Mbotho.
Brigadier Gininda, what you are answering me is not relating to the decision you took when, after you listened to accused number 1. You're not relating to that. I'm talking about the decision. You listen to the contents. Firstly, you guard against the rights not to be violated. That's all. Is that so?
Yes, and I did.
Yes.
I did
Number two.
give him his rights, my lord.
Number 2, I'm concerned about if you know what are the elements or the requirement of section 219.
My lord, the section that was read to me says you can't use a confession made by person A on person B. That's the essence of what was read to me, my lord.
Yeah, I hear you.
I'm not confused. I'm still on section 219. I'm going to argue on section 219 based on what, as the source of the first person you received the information from accused number 1, which necessitated you to take this person to a relevant person who can take a confession from accused number 1. There are safety measures that are provided by section 219 to say that confession, if it comes to your attention, being a brigadier, to say what he is telling me is also involving other people in that confession. Do you understand now?
I understand, but I don't agree with the assertion counsel is telling me. My understanding of that provision, my lord, it simply says that confession can only be used insofar as the person who made the confession. You can't spread it to accused number 2, 3, 4, and 5. That is the assertion. That is the essence of that code. In other words, you collect that evidence, that person is confessing, you will deal with that evidence if the court admits it, insofar as that person who made the confession. Not that you can't listen to it.
Lana ke ngiyamuzwa ummeli into ayishoyo ke kodwa ke lokho eqeda ufunda kumina manje uthi yebo lo muntu angakhuluma uyayenza ke le confession kodwa ke isetshenziswa kuyena kuphela ayisetshenziswa ku number 2 ku number 3 ku number 4 no ku number 5 kodwa ke uma sekuyukuthi manje inkantolo iyavuma ukuthi ilaleleke ila izosetshenziswa uyena.
That aspect I'll canvass it. My lord, I think it's appropriate time to adjourn.
What's the time now?
It's 3:30.
3:30.
Yes.
Yeah, your last question was?
I'll canvass it tomorrow and leave it for argument later. So the church is.
Are you available on Gomso tomorrow?
Yes, I am.
Okay. Okay, we adjourn until tomorrow at 10.